Hello, everyone. This is Tom Fox back again for another episode, and I can't tell you how thrilled I am to have Simon Airey and Caitlin Sheard on the podcast. They wrote a really interesting article sometime back in the summer. I came across it in August, and it is entitled Cross-Atlantic Impact, DOJ and SFO Self-Reporting and Enforcement Priorities. And I can't think of a topic that's more pertinent in the anti-corruption world now, but now we've had the failure to prevent fraud offense go live, and I think that may even have implications for our talk. But if you're into jurisdiction, if you're into geekness, we got the podcast for you today. So with that incredibly long-winded introduction, guys, welcome, and thank you so much for taking the time to visit with me today.
Thanks so much, Tom.
Thank you.
Simon, I'm going to start with you and ask you if you could tell us about your professional background and your current practice.
Tom, by qualification, I am a barrister, the kind of guy that typically goes to court wearing a wig. But I work for a global law firm where I head up the investigations and compliance team. In plain English, that means fraud, bribery, corruption, money laundering, sanctions, tax evasion, those type of economic crimes that we see quite a lot of today.
And Caitlin.
Tom, hi. I'm a partner at McDermott Will Schulte. I'm based in DC. My practice focuses on investigations and compliance with a focus on cross-border matters. So I help companies investigate misconduct all around the world. I've also counseled them on the decision to disclose that misconduct to DOJ, and then, of course, sort of navigate what comes next after a disclosure is made.
All right. So let's just go directly to the article, because I really found this to be a great article. You synthesized a lot of information, both in text and a chart format that I thought was great. So I wanted to maybe start with, what do you all see as the incentives or not for self-disclosure? Have they increased under the Trump administration in the U.S.? And for Simon, where do you see this in the United Kingdom currently?
Sure. So I think on the U.S. side, to kind of pull back and provide some context, Tom, many of your listeners will know that DOJ has been encouraging and incentivizing self-reporting for years now through various iterations of department policies. I do think that the incentives have increased recently this year with updates to their corporate enforcement and voluntary self-disclosure policy. So that updated policy, it's now more streamlined, more company friendly, and it provides more assurance to companies that if they do voluntarily disclose misconduct, that will sort of lead to a declination. So the incentives have been increased in that respect. And maybe Simon can talk a little bit about where things stand on the UK side.
Yeah, look, we have had some recent guidance, Tom, from the Serious Fraud Office. That's the main prosecutor in the United Kingdom, which essentially tries to clarify and improve upon previous guidance, suggesting how companies might be able to get the type of incentives and benefits from a voluntary disclosure. I don't think that a number of those incentives were as clear as they could have been. They are not as generous or as clear as they typically are in the United States. But if we cut through the guidance, what the SFO is telling us is that if you make an early disclosure, if you cooperate fully, then it will almost be automatic that you will be invited in to negotiate a DPA. What do we mean by that? First of all, there's no automatic right, but there is an uptick in the rhetoric suggests that if you do cooperate and you're prompt, then in those circumstances, that invitation will follow unless there are exceptional circumstances in play. What does it mean by negotiate? There's no right to a DPA, and unlike the United States, the court needs to approve a deferred prosecution agreement. So to that extent, there is no assumption that there's going to be a declination to prosecute. That gift is not with the SFO. Ultimately, it has to be approved by the court. So a bit of a difference there, but an attempt, I think, to bring the position closer to the United States and to give greater clarity to companies about the benefits that may follow if they do make that all-important decision to disclose.
When I was a general counsel, when I went outside to consultant, and even up to 2025, I've characterized the decision or not to self-disclose as one of the most difficult a board of directors could make. And that obviously all of us know what the potential consequences are, but do you feel like now, and I'll start with you, Caitlin, there are sufficient incentives in place where this can be a real option for a company, maybe as opposed to even under just 18 months ago, where it was still a very difficult decision to do. And we'll start with the U.S. and then move to you, Simon.
Sure. So I think the incentives are there. The incentives are real, but I still think the self-reporting calculation is not at all simple. Companies are being promised guaranteed declinations, but declinations themselves are still a big deal. If you get to that point with DOJ, you've probably spent a lot of time in discussions with DOJ. You've probably spent a lot on legal fees. You might have to pay some disgorgement amount. There's still going to be sort of this public declination letter that could create some negative publicity for you. It's not exactly surprising that companies aren't exactly lining up to self-report under those circumstances. But for a company that has identified real identifiable serious misconduct, particularly if there may be whistleblowers involved or other reasons to think that the government may become aware of that conduct, then there are very real incentives to self-disclose.
And Simon, you mentioned the guidance provided by the SFO and your thoughts around its clarity or lack of clarity. And you also talked to us about the court involvement in the United Kingdom. Do you feel now that the conversation in the UK has gotten, I don't want to say easier, but more straightforward around at least the decision to self-disclose?
In a nutshell, Tom, no, I still think it remains an enormously difficult decision for a company. And that's because the downsides of a voluntary disclosure are still immense. There's no hard and fast rule in the United Kingdom, but by and large, if you cooperate fully, if you make a prompt disclosure, you might expect fines to be ameliorated by, say, 50%. But the cost of an investigation, the fact that you might get sued civilly for stock drop consequences is still there. The reputational damage, the impact it might have on your investors and your bankers and your insurers and your customers is still immense. So it's a tough decision. What I think has changed in combination with the recent guidance is a really fundamental change in the law in the United Kingdom, which means that companies can now be prosecuted much more easily than ever they could before. If you combine that with the sharpened guidance, I think it becomes a little bit more compelling that the need to consider that very difficult decision is going to be more frequent. It's a tough one still, but because of that change in the law, it's something that companies are going to have to get used to more than ever before. In essence, and for quirks of English law, it was very difficult to prosecute companies in the United Kingdom. Why? Unlike the United States, there was no general concept of vicarious liability on the part of a company for the acts of its employees or agents. In essence, you had to show that the board was involved in that criminality or people to whom specific authority had been delegated. If they were not involved in the crime, there could be no prosecution of the company. Fingerprints and footprints were rarely seen in the boardroom, as a result of which it was almost impossible to prosecute companies successfully. The law has now changed. Those limitations have been swept away, and we have seen the most seismic change in English law for 150 years. The director of the Serious Fraud Office said, "This is the most significant boost to the SFO's ability to investigate and prosecute crime in over 10 years. He's wrong. It's ever since the SFO was invented in the 1980s. In fact, impediment in the law goes back that 150-year period I mentioned. And so the change that we see is immense. It's something that applies to companies overseas as well. So your listeners are going to be very interested, I'm sure, to understand how precisely those new laws work.
Simon, you mentioned the seismic change in UK law, and we are recording this in early to mid-October, somewhere in there. But anyway, after September 1, when the failure to prevent fraud offense became effective, is that the law that you feel is so significant, the change in the law? And I'd also like to overlay the director of the SFO, who's brought, seemingly from where I sit across the pond, a very different energy to the Serious Fraud Office.
I'll take that first point last, Tom. The director is determined to use his new powers. He is not in any way suffering from an impediment of political oversight. He's made it plain that his duty is to investigate and prosecute. It is clear that he is not going to be directed by government in that regard. And I think he also takes the view that it is important for the integrity of the City of London and the United Kingdom, in particular after Brexit, that it is kept clean. We hear anecdotally that he is very keen to prosecute as soon as he can. So I do not think we're going to see the time lag of many years that we saw in relation to the first prosecutions under the Bribery Act, for instance. Now, a lot of lawyers were inevitably banging the drum about that and threatening that they were going to go to jail. We didn't see that for quite some time. This is different. ECTA now covers a really expansive range of economic crimes that, putting it bluntly, occur in corporations day in, day out. I'm sure my US colleagues and the DOJ felt that in many respects the SFO was pretty lily-livered about various prosecutions. That's not fair. The law did not permit the SFO to prosecute in the way that it now can as a result of changes in the law that came into effect on the 26th of December of 2023, and latterly in relation to this new criminal offence that applies only to corporations of failing to prevent fraud. That came into effect on the 1st of September of this year, 2025.
So, Caitlin, the timing of a self-disclosure. Under the prior administration, we heard the phrase, the need for speed from the Department of Justice. And we had pre-pandemic a self-disclosure from Cognizant Technologies in 2 weeks from first notification to board of directors until self-disclosure, which I and I think many others took as the gold standard. Is that still the gold standard in your opinion? Can a company consult counsel and make a reasoned decision over some period of time, or is it now, oh my gosh, pick up the phone, call the DOJ now?
I would not counsel any of my clients to immediately pick up the phone and call DOJ. I would absolutely suggest that they consult with counsel and make a very reasoned decision. I will say, to your question, every case creates a precedent for others to some extent, but there's not a hard and fast rule on timing in the US. You mentioned 2 weeks in the Cognizant case. I think that can be considered a gold standard. In my experience, I think that is an incredibly fast turnaround. So it's not so much that every company needs to meet that standard. I think it's more that if it's taking a lot longer than that, then you should be prepared to explain to DOJ why. You should be able to defend what you were doing in that time, what investigative steps you needed to take to determine whether potential misconduct actually occurred, to be able to make a disclosure in as prompt a time as possible while still doing what you needed to do on the front end to make sure that you knew the facts before going into DOJ.
I would like to, first of all, I was so pleased to get a UK and US lawyer together for this podcast. And I'll start with you, Simon, because when you try to talk to either U.S. lawyers in the U.S. about the failure to prevent fraud offense, or in-house compliance officers or in-house counsel, they inevitably say, we have an anti-fraud program. We have a very robust anti-fraud program. And we have had a lot of trouble convincing U.S. companies and their U.S. lawyers this is very different than what they are thinking about in terms of an anti-fraud program. I want to use that as an introduction to ask you, can you explain the potential traps a U.S. or non-UK company even could have if they take a very narrow view of fraud in the context of the failure to prevent fraud offense?
Yeah, let's start with the word fraud. First of all, whilst it is described as a failure to prevent fraud, it's a bit of a misnomer. It's actually a failure to prevent a range of economic crimes that are defined in schedules to the legislation, and they are broad. As I said earlier, they are the type of things that occur in companies day in, day out. Various different species of fraud under English law, tax evasion, cheating the public revenue, false accounting, a huge and expansive crime of creating false documents, misrepresentations to the market, auditors, bankers, insurers, investors, joint venture partners, etc., can all be included here. As I said, this is the kind of stuff that hitherto has not been capable of being prosecuted against companies, but now can. And it's seismic because it covers day-to-day activity that the likes of Caitlin, myself, and our white-collar colleagues see all of the time. There is only one defence, Tom, under the law to this offence of failing to prevent, and that is to show that you had in place reasonable procedures that were designed to prevent that conduct. In short, an all singing, all dancing, properly functioning and implemented compliance program. Many companies have got fantastic anti-fraud programs that are typically inward-looking to prevent fraud against their company, perhaps by third parties or even their own employees. What we're talking about here are frauds perpetrated by any member of staff, any person or entity associated with the company, if they commit any range of offences against third parties, then the company is prosecuted merely for failing to prevent. As I say, you have to show that you have a defence of reasonable procedures, otherwise you will be prosecuted. What does that mean? We've got 44 pages of government guidance that tells us what to think about, and there are 6 core compliance principles in that guidance. We've seen similar principles before in relation to the Bribery Act. So those who are sophisticated in terms of compliance programs won't be surprised by the type of things that they need to embrace. But because this is English law, whatever program you have in place needs to be fit for this broad range of offences, the English law jurisdictions that apply and the hooks, and also bearing in mind that this law has very expansive extraterritorial elements, which means that it can apply to behaviours and companies overseas as much as it applies to companies working in or through the United Kingdom. It's that huge kaleidoscopic aspect of the law that really has made it a sea change in terms of the ability of the SFO and other agencies in the United Kingdom to prosecute companies for the first time in that 150-year period I mentioned.
Caitlin, I want to take a similar approach that I gave to Simon, but I want to change the question to the DOJ and their new focus, certainly on cartels and being reclassified as foreign terrorist organizations, and the look by this administration to both Mexico and Latin America, overlaid that with economic crimes such as the FCPA. And do you find that companies outside the United States are beginning to understand that they need to think about business operations in Mexico? They need to think about business operations in Brazil or Central America or other Latin American countries, in a way they perhaps hadn't before?
Yes, I think that's right. I think now with the changes in DOJ's approach and priorities, it's a great time for companies to sort of update their risk assessments, and in doing so, to particularly look at their operations in places like Mexico, Brazil, other places in Latin America where there might be those cartel or TCO ties that DOJ seems to be so focused on. This is not an area where we've really seen enforcement actions in the past that had bribery to do with TCOs and cartels. But I think now people are thinking about where could that risk arise? Could that risk arise with our logistics vendors or other third parties that could potentially be operating in cartel controlled areas, for instance, and may have some cartel points or interactions there. So I think being aware of the risk is the first step, and then thinking about what to do operationally to address it. So that might be updating due diligence procedures, looking back at your due diligence questionnaire, seeing if you're asking the right questions to sort of untangle some of those potential ties that could be out there. Even though we don't have the reasonable procedures defense like in the UK, I think DOJ still expects compliance programs to be risk-based and tailored. So I think that requires a continual updating of your risk assessment to address emerging risks and also to address enforcement priorities of the administration.
How do you all think through self-disclosure on a global basis? And prior to even this year, I would have said to a U.S. company, you have to consider the U.S. FCPA, you have to consider the U.K. Bribery Act. Brazil, Germany, other countries, France now have robust anti-corruption programs. But we have now broadened out to make risk, if not greater, different. How do you help a company think through a self-disclosure to multiple jurisdictions? Is that something you all are either getting questions on or you're counseling clients on?
Let me take that, Tom. Yeah, it's a conundrum. If you have a multinational It may well be that behaviours that have taken place in New York have also been replicated in London, Hong Kong, or financial markets around the world. If you've got a highly regulated entity, there may be disclosures that are necessary to regulators as well as to markets. It may well be that under UK legislation relating to money laundering, there could be a requirement there to report a mere suspicion of criminality. All of these things coalesce at a very key time, and understanding in what order you might make those disclosures, whether you separate them, whether they are staggered or whether they ought or must be made at around the same time, it is a tough one. What we have is an indication from the Serious Fraud Office that they will not look kindly on the type of disclosures that seek to forum shop, for example, where they might get more benefits by making a disclosure, let's say in the United States, because they've got a better chance of a declination. The sense is if they see that type of arbitrage as regards timing, that will not be considered cooperative. Now that's fighting talk, and that makes it really difficult for companies who in the past would very specifically want to do that to minimize impact, damage, cost and expense. They've got to think again. I think what we will be counselling our clients about is to give very early consideration to this when something bubbles up. Have your people understand that if it looks as though there is something that is serious, if it looks as though there's something that might leak out in any event, if it looks as though there's an expectation you'll have to make an early disclosure, get that triaged rapidly, preferably in a privileged environment, but also taking account of the differences and the similarities that exist between different jurisdictions to aid you in the right way to go about doing that.
I think there's a bit of a timing tension here because there is an expectation under both the UK and the US guidelines that the disclosure be prompt. But I think what Simon is saying is that it also needs to be incredibly thoughtful, and it's an incredibly complex decision, particularly where you are operating in multiple jurisdictions. You need to make sure that you have the right people in the room advising on what's to come, and that takes time. And this is a situation where I think taking that bit of a beat, taking a bit of a pause, even if it lengthens the overall time to making the disclosure, is worth it in this case, because this is an area where you really don't want to sort of accidentally step on any tripwires by making a quick disclosure in one place that could have an impact somewhere else.
Caitlin, and this comes back to a question you raised earlier about it being difficult. Yes, we've got a real clear statement from the Serious Fraud Office. They expect suspected offending to be reported to them promptly within a reasonable time of that offending or suspected offending coming to light. That's fine as a statement, but in reality, you've got to understand what that suspected offending is. That whistleblower could be delusional. They could be Machiavellian. They could be absolutely clear in their thinking. But one way or another, a company has got to understand the nature and the extent of that before they go reporting anything to anybody. Otherwise, hairs will be set running and all manner of consequences may flow. It is a tension, exactly as Caitlin said, but it therefore means that companies have just got to be ready to assess these things perhaps earlier than before, because that guidance is clear. They do expect it to be done promptly. They don't expect you necessarily to do a full investigation. But as Caitlin said earlier, if you're not going to be doing it, let's say within that magical 2-week window, which I think is fanciful, then you need to be ready to defend what you have done and why it has taken you the time that it has, if you are to get the full credit that you would expect.
I'd like to end by asking you both about the anti-corruption, anti-bribery laws of your respective countries. In the United States, obviously, the Foreign Corrupt Practices Act, and in the United Kingdom, the Bribery Act. And I'll start with you, Caitlin. From what you've seen from this administration, both in terms of guidance they've given us, their prosecution of individuals, which has continued. I was unsure what FCPA would look like going forward, but I believe it can be almost as robust as we saw previously, particularly when it comes to having compliance programs prepared to self-disclose. So Maybe get your general assessment of where you think FCPA enforcement and even FCPA compliance will be in 2026 and beyond during the Trump administration.
It's a great question. We've been tracking this closely, and just a few weeks ago, Acting Assistant Attorney General Matthew Gagliotti gave 2 speeches where he was touting DOJ's recent wins in the white-collar area, and he said in no uncertain terms that white-collar enforcement, including FCPA enforcement, remains a priority. But I think anyone in this space can certainly sense a slowdown, not surprising at all after the FCPA pause and the new sort of more narrow enforcement focus. But looking to the future, I think one of the most interesting things that we heard from Gagliotti had to do with DOJ's recent whistleblower awards program. And in one of those speeches, Gagliotti said that in the past 4 months alone, DOJ has received 313 whistleblower tips related to white-collar violations, and it found that 120 of them warranted some sort of further investigation that included in fraud-related areas. So I think that shows that we could see more activity out of this DOJ, or at the very least that there could be kind of a well of whistleblower tips that could be investigated under future administrations.
And Simon, the same question with the Bribery Act. Once again, I have to overlay with the new director. Do you see a robust Bribery Act enforcement regime going forward into 2026 and beyond?
I do. I think if you look at various task forces that have recently been set up with the SFO, they have a real focus on international bribery. Nothing's changed there. I do think that ECTA is the real thing that's going to expand the whole purview of this. I said right at the outset that there were certain changes that have been introduced in December of 2023. They cannot be overlooked. They now mean that anybody who's a senior manager of an organization, if they commit a whole range of economic crimes, including bribery, they now can infect a company with that criminality. That has hugely expanded the cohort of people who will now put a company at risk. Understanding how those laws really operate will make it very clear why the SFO is as excited as it is about these changes. In relation to this latter offence, it's really important to point out that there is no reasonable procedures defence. If a senior manager, which is defined as anybody who plays a significant role in making decisions about the management or operation of a company, or somebody who plays a significant role in actually managing the company, if they are implicated in any of those wide range of crimes, the company is guilty of an offence. No reasonable procedures defence. That is exciting the SFO, I think, probably more than the failure to prevent. And so you bring all of these things together, and I think these are, from the SFO's perspective, really quite exciting times. These are pioneering changes which are giving it powers that it's never, ever had before, and I predict it will not be long before we see that first investigation with a prosecution to follow. Remember that these are everyday activities in companies. You mentioned bribery, a little more esoteric. It occurs in crazy places around the world. Often it takes a long time to investigate through mutual legal assistance and getting evidence from overseas. That's why we often see a time lag. The offences we're talking about here, where either the company fails to prevent them or a senior manager perpetrates them, are routine stuff in corporations all around the world. So that, I think, is going to give rise to, I wouldn't put it as a feeding frenzy, but I think we are going to see some very early activity. I really do.
Unfortunately, we are near the end of our time for this episode, but before we leave, I wanted to ask you both if our listeners wanted any more information on you all, on the firm. We're going to link to your article in the show notes, so that will be in there. But what might be the best place or places for them to go?
From our point of view, we've got tons of collateral and material that can be obtained from our website generally, and linked, of course, to our bio pages on the website. I have prepared, as it happens, both an electronic and a paper pack, yes, we still do paper, of all ECTA-related materials, articles, top tips, the government guidance itself, which, by the way, refers to publications that we at McDermott, Will and Schulte have authored, together with other guidance relating to the financial services sector, all in one place. That's probably a great starting point for anybody who's interested in learning more.
Caitlin?
To echo what Simon said, our website is a wealth of information. Our team in the U.S. has been tracking developments in the FCPA enforcement landscape, as well as DOJ compliance policy changes and updates. So please find us there.
Well, guys, I wanted to thank you so much for taking the time to visit with me, and I hope we can continue this conversation.
Thanks, Tom.
Tom, thank you. It's been a great pleasure. Good talking to you.